what is the recent trends, and eventually, all in all, the main question will be what is going on. Now, I'm not an expert, unlike the panel we have here. I like to think that I'm basically a kid who does not know much. But one thing I think I'm good to do is to ask questions. Questions such as, are we a pro-arbitration regime or are we conservative? Do we have a lot of judicial interference, or is the judicial interference fine-tuned to the corporate guidance? Do we have any enforcement problems, enforcement of the arbitral awards, or that what would be the role of arbitral institutions regarding the enforcement of arbitration awards and the overall procedure? Last but not the least, the delays in the proceeding. Are the delays worth letting go of litigation, or are the delays worth it? Should we pay the hefty fees of arbitration if there is going to be delays? Or the truth remains, are there any delays? And honestly, who better to discuss all this than our panel here? Then I would not take up a lot of time with some sort of these questions. I hope the panelists can enlighten us with their wisdom and discuss with us about their opinions, their insights in the matter. And with that, thank you so much again for being here. And I look forward to the insights and the wisdom of all the panelists. Thank you so much.
Thank you, Mr. Bhamra, for those insightful opening remarks. They truly set the stage for the crucial discussions ahead. We now move to a segment we all have been eagerly awaiting. It is an immense honor to invite Hon'ble Mr. Justice Jasmeet Singh, Judge, High Court of Delhi, to address the gathering. Your Lordship, your profound understanding of the law and its practical application will undoubtedly enrich our collective knowledge.
Justice Kotiswar Singh, Justice Rastogi, Justice Hemant Gupta, Param, distinguished guests, good evening. I've been in the arbitration roster for about 6 months, and I've had a very close look at the development of law. I have only 2 or 3 questions which I would like to ask for the distinguished panelists, because these are questions which crop up every day in my roster. So the law is very clear that the judicial interference is very minimal. The law is very clear that the courts should have a hands-off approach, and it is party autonomy. It is the arbitrators. Even if the arbitrator has gone wrong on an appreciation of fact, or if it's a plausible view, the court should not interfere. But the fact of the matter is, day in, day out, we receive, which are to say howlers. If you don't interfere, you feel that there is some grave injustice being done to the party who has come to court. The question is that would the court interfere? Keeping in mind that the view of the arbitrator is a plausible view, but because 34 is the first time when the award goes through a judicial scrutiny. Now, there are arbitrators who are not experts in law, they are experts in their particular field, but they have ignored something which is so basic. So, as courts, are we to ignore it? As courts, are we to interfere? This is a constant struggle with the courts at the 34 level. Another thing which keeps bothering us is that whenever you hear a 34 petition, there is an award which runs into about 100 plus pages. The councils, because it runs into a couple of 100 crores or maybe more, the counsels are the best in the field, and they would want to argue for days altogether. So should there be a timeline in like we have an arbitration proceeding that it has to conclude within 6 months plus 1 year? Should there be a timeline 34 court that the moment you issue notice till the final order, there is a timeline, maybe 5 hearings, maybe 4 hearings, maybe, because the essence of arbitration is a speedy disposal. So this is another issue which is constantly cropping up, because I am dealing with 34 petitions of the year 2016, 2017, and to my mind that defeats the whole purpose of arbitration. Another point which I would like to flag is that should we not have specialized rosters? There should be a 34 roster, there should be a appellate roster who are only dealing with arbitration, because they would know that the Honorable Supreme Court has said these are your boundaries, these are the parameters. So that's the idea being that arbitration is an alternative dispute resolution forum. The essence of arbitration is a speedy disposal, but somehow I am getting the feeling that it is being lost. So these are questions and these are my views. Thank you. Thank you.
Thank you, Your Lordship, for that enlightening address. Your words deeply resonate with all of us. Continuing with the series of distinguished addresses, I am the honor of inviting Honorable Mr. Justice Ajay Rastogi, former Judge Supreme Court of India, to share his invaluable perspectives with us. Your Lordship, your experience at the Apex Court offers a unique lens through which to view the contemporary challenges and opportunities in arbitration.
Good evening to all my young friends who are law students, lawyers, the upcoming generation who will take the baton of legal fraternity in times to come. My brother Justice Kotiswar Singh, brother Justice Hemant Gupta, brother Justice Jasmeet, and sister Shruti, and last but not the least, this young fellow, because he's the one who is always taking the lead. I'm so thankful that you are giving me this opportunity to address whatever the thoughts have come forward, whatever problems which the courts are coming across, particularly in the field of arbitration. I'll just condense myself and straight away come to the point which Brother Jasmeet has put to us. ADR is a mechanism which is universally acceptable. People say that this mechanism has been introduced because there is a tendency in the judicial courts, and that will be the reason for this resolution has come forward by amendment of 2002, basically section 89 of the CPC. But nobody has been able to of long pendency in every sector. If I share my own experience, I came in 82 in profession. There was a pendency in courts. 2004 I became a judge, pendency was there. And I thought that I am now become a judge of the High Court, I will see the pendency reduced. With all commitment and all my precision to work. But I find that after 19 years of serving as a judge at the High Court and Supreme Court, I left the pendency as such. To the contrary, it has increased. When I came to Supreme Court, I did the figure. 80 I came along with my brother Justice Hemant Gupta. The pendency was 69,000 and all, the Supreme Court. And when we left Supreme Court, 2023, the pendency was 89,000. What I want to tell you is, there is something wrong somewhere. and it needs a course correction. How the things can be corrected? Everyone has to sit together and find out a solution which is universally acceptable. And we are able to do it. You must have attended so many seminars, so many symposiums, so many different kind of forums where this issue is being raised. But I don't think anybody has been able to find out a solution. So this ADR mechanism is not inducing the pendency of courts. ADR, to my understanding, is a resolution where parties may feel that we have been heard, opportunity is given to me, a fair justice has been done, procedure is acceptable to the parties, and with a course correction we can reduce the timelines. But I think we are not been able to take care of that timeline schedule also in the arbitration process. I've been given the words clause. I'm very thankful to you. These two words, to my understanding, is a complete arbitration provision, act of arbitration up to 96, I will say directly. Clause start when you take a call as to what should be a forum of clause of arbitration in the agreement. Because it's your autonomy. You are the master. You can take a call what are to be identified, clarified while putting this clause of arbitration in the agreement because you are commercial contracts. You don't need anybody's assistance. You are a master of your own. Field experts. You know where the shoe pinches. So my request is, this is the way by which the system starts. I take only 2 minutes further to come out what Jasmeet has put to us with my short knowledge on the subject. When you come to the closure means the arbitration process is closed. So it is in between. We, with all respect, are giving and promoting ad hoc arbitration. I am adverse to it. I always say promote institutional arbitration. Institutional arbitration has so facets. Transparency is there. Time schedule is there. Fee which is prescribed, which I mean just said, is there. Timelines are fixed. Statutes say 1 year under 29, 1 year can be completed, but we take longer time. And if it is an institutional arbitration, all things can be managed. Confidentiality is there. A draft award goes to the center for just to examine as to whether it will be followed or not. So you reduce the burden of 34. But I'm sorry that good reasons, institutional arbitration is not taking off in our country. Go to different countries, go to SIAC, go to London, go to ICC. Perfect institutional arbitrations. People have faith. Arbitrators are those who are expert of the field. Arbitrators have a basic knowledge of the subject. They are trained. They are professionals. We don't have. And I always say we should not confine to judges alone as arbitrators. We should have lawyers. You should have a technical experts people as an arbitrator. They know the subject. And I'll just give you one example. One matter came to me from DIAC. Because Jasmeet is there. A month thereafter, there was a joint letter come to me on my mail. Sir, this is a technical and if you don't mind, we want a technical person to be an arbitrator. I said, I'll be the first man to refuse. Because I'm not an expert, but I gather knowledge from the lawyers, gather knowledge from the technical experts people, but still I'm not an expert. And we are not experts. We are all learners. We learn from the subject. We learn from the lawyers. We learn from the litigants. And whatever we have been able to encapsulate in ourselves, we put in the work to the best of our endeavor in taking a course. So this is the system which has to work. Brother Mr. Hemant is there. This institutional arbitration works very well. Jasmeet, if it is possible, I have been appointed an arbitrator by the court in a non-arbitration. And then the order was under the edges of institution. I was very happy. Every managerial work is being done by them. Every day they inform to us. They will guide us, sir, timelines are exceeding now. You can't give an adjournment. So there can be a cap on the overall arbitration which one can hold at a time. Just because I'll tell you one thing. We all the day give our declaration of 12 that I'll be able to do these arbitrations 1 year as per the statement. But I'm sorry. I'm giving a false declaration. If I have 40 arbitrations at my command, it's impossible for a man to complete that arbitration within 1 year. So what I think is, and one matter came to me, I share. It is from Chennai. One lawyer or a judge was appointed as an arbitrator, but they were exceeding the cap. So the institution has not accepted that arbitration's order passed by the court. So the matter came to the court reviewed it, and some other was appointed. That fellow came to the Supreme Court. I said, why you are here? He said, sir, I was appointed as an arbitrator. How can the court review and have some different arbitrators? So I had a view at that time that it might be possible that because of some declaration is going a clash of interest and all things. But I find no. The reason was that he was exceeding the cap. So I always say there should be a cap over the individual arbitrators which one is supposed to hold. If you are exceeding that cap, let it go to the other one. The timelines is to be followed in 1 year. We always take 6 months additional as a matter of course, which is unfair. So these things, if possible to follow, I think we are able to do justice with the statute which is being legislated for us. We are guided by it. If you come to 34, Jaspreet is absolutely right. And I'll tell you with my experience. Whenever there was a seminar or symposiums being held for 34 and 37 distinction, there are plethora of judgments, but I'm sorry to say, we are not being able to find a distinction between 34 and 37. Every 34 goes as an appellate forum, and every appellate forum goes at 37, and then comes to Supreme Court, and Supreme Court also treats as an appeal. Right? Whosoever matter landed in the Supreme Court on 136 is being considered as an appeal to us, and yet to examine. But my request is, if possible, 34 and 37 should be clubbed, and there should be one. Because if 96, 40 is the act, amended in 96, we are in 2025 now. If you are not able to make a distinction of 34 and 37, better is club it, one hearing of the award, and even if somebody does not agree, come to Supreme Court and let the Supreme Court take a final call. That can be one solution which is possible. Otherwise, this 34, 37 struggle will go on, and you consume additional 5 years minimum to clear 34. We just said now 16, 34 is pending. If 16, 34 is pending, if just please sit 24 hours and 24 by 7, if you are not able to clear 34, how 37 and then Supreme Court? So the question is, your landing matters for nothing. And down the line, we have to trust. Just please, I'll tell you one thing. Every award at every stage is being doubted. We have to trust somewhere. Somewhere down the line, you have to trust. Otherwise, the system will not work. There may be 1, there may be 2, there may be 3, which awards may not be acceptable on the face value for good reasons. But that 3 awards which are not acceptable on the face value will create a problem for 97 awards which are perfect in order and the procedure being followed, and ordinarily there is no error apparent which requires to be considered. So how to decipher? It is the presiding judge and my brother Justice Speak being on the bench. It is for him to take on. Nothing can be said. And this is the way in which we have to work. He is right in saying, I don't know what is wrong with us. The awards are very, very lengthy. I have also come across while I was in the Supreme Court. 200 pages. God knows what is mean. In a fixed story will be completed in 75 pages. The award goes to 200 pages. God knows what is happening. We go on citing judgments and judgments and judgments. God knows These awards doesn't. These are absolute factual appreciation. And we go on, quotations are such. If you take up, God knows, I'm sorry to say whether drafts are being prepared by whom, God knows. I can't say at the moment. But the question is how long it goes on. Chat GPT, I think if somebody use Chat GPT, I'll tell you. No, there is a software. If I put that software, from this award are being taken note of from Chat GPT. Am I right?
Yes.
So nowadays, every award person who takes an award, he is clear in mind. So my request is, Jasmeet, if you, since holding the roster, please request those who come forward. Please shorten the award. Only the point in issue which is being hit by the parties as an issue of controversy must only be looked into. Not the entire history. And we go on. Some awards have come to me, to find out where the issue lies for consideration. God knows, some God is named to me. And so unless you have an assistance of a lawyer who has gone through the file for at least 3 or 4 days, then only you will to decipher me, sir, page 93 is the page from where the award has to be examined by you. So that the thing goes on. And post-award is a difficult task which we are unable to find out any solution. Sorry, God knows where the issue pinches to us. As in our country, people say, to get a decree is possible, but to get the decree implemented in execution creates a lot of problems. Same thing is possible here. But I find, if you go to SIAC, implementation is very smooth. Takes not take so much of time. Go to London, the arbitration centers, not take time. What I personally feel is that every stage there is an application at the stage of execution, and at every stage that application becomes an appellate jurisdiction by the courts. So my request is, and my view always remain is, if somebody has succeeded in obtaining a decree, and word use I, obtain a decree by a competent court, then all technical objections as far as possible, which are technical, must be ruled out. He must get he is a recipient of the decree, he must get it. Unless you find that particular objection goes to the root of the matter. Ordinarily should not be interfered. Jurisdiction is not there, that is not that, gone. Parties have looked into the matter. I'll not take more time, brother, only 1 minute. Jury's problem is seat and venue. One matter came to us. In arbitration clause, there was no mention about the clarification of seat. When the arbitrator was appointed, he had the first meeting in Gurgaon. He had 2 or 3 hearings. Thereafter that arbitrator recused. Then the parties appointed an arbitrator who is in Delhi. So rest of the matter was conducted in Delhi and the award was passed in Delhi. Now when 34 in stage came, one party went to Chandigarh and filed 34. The other party came to Delhi and filed 34. Chandigarh was slightly faster court. They decided 31 said we have a jurisdiction. By the time Delhi would take a call, the party came to Supreme Court. On jurisdictional issue, matter was lying before the court for more than 7 years. When the matter came to us, myself and Brother Sanjeev Khanna was there. I said, brother, let us take on the first day of hearing and decide this issue. We said nothing doing. 20 is very clear. Subsection 1, 2, 3 is very clear. We said, if the parties are not mentioning the place of seat in the arbitration clause, then the first sitting is the seat. All subsequent are venues. Venues can be changed at the discretion of the parties, but seat can't be changed. And seat will be the co-terminus for the purpose of identification of 34. But still I have been told that this seat and the venue is still going on, God knows where it is. And people are not able to find out the solution where to stop themselves in taking the jurisdiction. And post-award, my brother Justice Hemant Gupta will tell you where the shoe is pinching to the people and execution is not possible. Whether Kotiswar is there, he must be dealing now with the matters of in 136 of arbitration, God knows how the thing's rolling. Jasmeet is actually into 34, so he has a first-hand experience of working in 34. He has already, and I'll tell you one thing. The pain which he has shown, all of us to listen and to find out the solution. I'm very thankful, Jasmeet, that you have been able to tell us what is the problem which the court dealing with 34 is facing as on today. If Delhi court is facing, which has a long matters pending, think about the other high courts where 34 is not that much in volume as such like in Delhi. But still every court is facing the same problem. And I fully agree with him, there must be expert in the field. In High Court, the problem is we change the roster without knowing it, what judge has different background or what kind of a matters he can deal with. He just has to take a call. So I'm so thankful for giving me this opportunity to express myself in the shortest possible time. I'm so thankful to you once again. Thank you very much.
We are profoundly grateful, Your Lordship, for sharing your wisdom and insights. Our next speaker needs no introduction. It is an immense pleasure to welcome Honorable Justice Hemant Gupta, former Judge, Supreme Court of India, to the podium. Your Lordship, your distinguished career and profound judicial acumen make you address a truly anticipated part of this evening.
Good evening, Brother Kotiswar Singh, Ajay Rastogi, Jasmeet. Yeah. No, age is affecting. I'm the senior most amongst all of you. No, the issues, firstly, I must congratulate Param Bhamra, who has penned this book. I met him almost a year back, and he came out with wonderful ideas about mediation, about arbitration, and he associated me in certain conferences as a judge or as a panelist. And here I am, actually, he asked me to write a foreword. No, when the book came to me, manuscript came to me, I said I will use AI to summarize the book, to have something of my credibility. But the paid version of ChatGPT was expensive for me. So I gave up. Then I relied upon Param to write a short review, and then I gave it dressing down. The questions raised are pertinent by Justice Jasmeet, Ajay Rastogi. But the problem is, there is no simple solution of the problems. As the one who is handling 34, is a theory for me, but practical for him. It's very different. 34, actually, when I joined profession, that's 96, I came into the force. At that time, I was lawyer. I found a clause, one of the clauses to set aside an award was against the fundamental policy of India. What is fundamental policy? How you define it? So my first reaction was, this is going to create problems. And ultimately, relying upon 1940 judgments, the court said patent illegality is the ground of, fundamental policies, patent illegality. What is patent illegality? I think nobody can define it. Patent illegality is again subjective. I may find it is patently illegal. I may say it is justified. You can't put it. Ultimately, in our system, it is judge-made law. It is the satisfaction of the court which says that is a patently illegal or not a patently illegal. No judgment can define that this is the patent legality. Of course, in some case, when we want to interfere, we will draw our own grounds of patent illegality. But it will be very different. In each case, it will be different grounds. very difficult to define what is patent illegality. I give the example like in second appeal. Second appeal is admissible, can be considered on a substantial question of law. What is substantial question of law? At least I was a civil lawyer, I dealt with second appeals as a lawyer and it was difficult to define. If the judge is satisfied that there is some illegality, you will say that's a substantial question of law, otherwise you let it go. You say no substantial question of law. It's the same thing as about patent illegality. About the awards, the issue is to what extent the court can. The problem is we are basically, most of the awards are by the judges or the former judges, written by the judicially trained mind, but they are kind of experts, engineers, etc. They are not the legal background, but they are on facts. Award is a question of fact. It is like a judgment where you discuss the pleadings and the evidence and then come to the conclusion. As we have said that case law is not required. Generally, in 99% of cases, it's a question of fact. But if non-judges have given award, the eye of scrutiny can't be from the judge's point of view. Judges, if we examine it as that say in that it is when the 34, you don't access but you exercise supervisory jurisdiction. Broadly see whether it meets the parameters. If it meets the parameters, fine. But the difficulty with the judges is we want to test it on our wisdom. That we are legally trained mind, we must examine it on the ground of what an award should contain legally. That's what probably is not warranted. The difficulty arises because we have grown with ad hoc arbitration, 1940 Act, ad hoc arbitration, 1996 ad hoc arbitration. So, as in one of the seminars in Delhi Arbitration Week, it was said that it's old boys club. You know, old boys club, like me. But basically, I have exercised the power of, on behalf of the Chief Justice to appoint arbitrators for 2 years under 2 successive Chief Justices. But to be honest, I never realized that institution can be an arbitrator. Because the system was grown up like this, that ad hoc arbitration. So you appoint ad hoc arbitrator. But recently I analyzed from a different angle. In Konkan Railways, the Constitutional Bench said that it is administrative power. Appointment of arbiters, Section 11 says administrative power. But 7 judges bench later in State Bank of Patiala versus Patel Engineering said that's a quasi-judicial power. Because if the judge is exercising power, it can't be administrative power, it has to be judicial power because judges are judicially, legally trained mind. But one interesting paragraph is in that judgment is that the 11th in the word can delegate, Chief Justice can delegate, designate an individual or an institution for appointment of an arbitrator. Like this, that institution can be asked to give the names. Institution can't be delegated the power, constitutional power to appoint an arbitrator. Only the institution will you will get the names from the institution and send it back to the court. That was not probably the purpose, but the fact remains that we are so ingrained with judicial system, notice, natural justice, principles of equity, all those things. And then there came principle of prima facie examination of the case, whether it's a time bar or not, whether there's an arbitration agreement or. Now 11.6 applications are decided by an order running into 100 pages, which is purely whether you appoint an arbitrator or not appoint an arbitrator and leave all questions to the arbitrator. But we are exercising that jurisdiction by elaborate examination. In one of the cases, Supreme Court has called the data from all the high courts that how many applications under section 11.6 are pending. 4 high courts were topping the list. That is Karnataka, Bombay, my parent High Court Punjab, and of course Delhi was also part of it. More than 600 to 700 High Court was 900 cases. 11.6. No, it was 22. Maybe the situation is improved. I don't have a data. National Judicial Data Grid doesn't give this data. They say the arbitration cases, whether 11.6 or 34 or 37, doesn't distinguish that. So there are challenges at every stage. Another thing which I want to share is that in the rest of the world, it is the institutions who appoint arbitrator. You know, people said that CIAC, London, Paris, but they are all institutions who appoint arbitrators. India has the dubious distinction where the courts appoint an arbitrator. And the court takes its own time because appointment is not a priority in the sense there are so many other cases deal with personal liberty, bails. High courts and constitutional courts have multiple jurisdictions. So commercial matters take a back state. So we need to decide how to go about it. Should we have institutional arbitration? There was one provision which was introduced in the Arbitration and Conciliation Act in 2019 to establish Arbitration Council of India. But it has not been established. Say, because on account of personal knowledge, the name was recommended to the Chief Justice in September 23, but the appointment was not approved by the Chief Justice of India. What do you say? What do you do? How do you deal with this situation? So, there are the grounds for improvement are required. And in a way, there's the bill which has been introduced in 2024, Arbitration and Conciliation Act Bill 2024. Apart from the other amendments, one of the major amendments is Constitution of Arbitral Appellate Tribunal. Yeah. Arbitral Appellate Tribunal, if the parties agree, will take away Section 34. So 34 away, at least 1 tier will be knocked down, but the fact remains the High Court will have the jurisdiction under 2 to 7. That is a basic structure. L. Chandra Kumar, 9 judges bench said it's a basic structure. You can't take away that right. And obviously 136 also ancillary is again a basic structure. So at least one level will go, principal civil court will go. It will be only the High Court under 226 or 227. And then 136. Once the High Court has examined it, still it will be better off. At least there will be reason recorded by the High Court. There are different problems. It's a happy occasion for launch of the book. I will not say anything more than that. So I congratulate Mr. Param Bhamra for taking an effort to write this book. It's not just another book on arbitration. It's a practical guide for the lawyers, for the arbitrators, students of law, for everybody else. Thank you very much.
Thank you, Your Lordship, for your inspiring words and valuable perspectives. We now move to a segment that we all have been eagerly awaiting. It is an immense honor to invite Hon'ble Mr. Justice N. Kotiswar Singh, Judge, Supreme Court of India, to address the gathering. Your Lordship, your profound understanding of the law and its practical application will undoubtedly enrich our collective knowledge.
A very good evening, everybody present here. Honorable Justice Hemant Gupta and Honorable Justice Ajay Rastogi, Justice Jasmeet Singh, as well as Shruti, and all the advocates here present, and of course today's man of the match, Param Bhamra, who is being forced behind this congregation, where we are able to share some thoughts on arbitration. Arbitration, as far as I'm concerned, I was born in the days of Arbitration Act of 1940. Arbitration Act, which made a change in 1996, as we know, when we have I had completed 10 years of my practice. By the time I tried to get a hang of this arbitration, and I got elevated, and so I didn't really went into. I had not really gone to thick and the issues prevailing in the Arbitration Act. But I remember Konkan Railways you mentioned also. Konkan was everywhere. There's so much of dispute among various high courts which they are administrative. It is a judicial function. So ultimately it was resolved by saying that administrative. Yet again, subsequently a view was expressed. It's not purely administrative. If we continue to do our job, in fact, when I was in J&K as Chief Justice, I used to assign every week Friday for this 11/6. And of course, why should I have so much of time and afford time for this? But then we realized that, there is always an objection from the side. Actually, there is no arbitration clause. Or if it is there, then it is already expired. I mean, this belated. So ultimately, in this appointment process also, we have to examine all these aspects. That's what I felt is something which needs to be again looked into by the courts as well as by the policy makers, how we go about this. Because I remember in Supreme Court just the last few months before, there was a case from Delhi High Court about 2010 matter, still on the issue of the appointed arbitrator. What had happened was there was a very huge clause on the appointment arbitrator. Almost one page, entire 2 pages, I think. In DDA, I think, and somewhere. So one, of course, bench should give us a verdict that yes, there is an arbitration clause. Another bench says, no, there is no arbitration clause. It doesn't really say. So on that, it has not started. 2010, can you imagine? That we are yet to start at the point of appointment of arbitrator. Only then the others, the process will start. So these are issues, of course, but then, as I say, it's evolving, and it's, I think, and we are going ahead, I mean, a lot of, I think, we are seeing a lot of development from various contributions from various high courts also, evolving law of arbitration. As far as this, I was told that this is the present scenario, landscape in the Arbitration Act. We see that, as we see, all of us know that we have gone through 3 phases. The first, of course, the enactment of the 1996 Act. But then we saw various impediments. It was sought to be improved upon. It was streamlined with the amendments which we know in 2015. Massive amendments were made in 2019 and 2021 to streamline ourselves with and to keep in tune with the evolving arbitration laws all over the world. Of course, 2015, as we know, it was basically meant to streamline the arbitration process by making it faster, more efficient, and less reliant to court intervention. And of course, again, that every arbitration is to be concluded within a year, and it can be extended with the consent of 6 months. Again, this is another area I felt myself in Jammu and Kashmir. Again, yes, the mandate of law is that there should be an extension, but what to do when the arbitrator recuses? There was a case where 2 arbitrators accused. So obviously by the time the timeline went off, so there was the other side said, no, that there should be an end to this matter. Then I had to, then there was some judgment from, I remember there was a Calcutta High Court which says, no, nothing doing, 6 months is there. But I don't know who was the Okay. So I also, I didn't know that Delhi High Court judgment. I also pondered about it. I said, well, ultimately, see, if there may be situations which is beyond the control of the parties. So I also agreed, then I realized that yes, then I was told that Delhi High Court has given. Fortunately, that has been upheld by the Supreme Court. Right. So there are many situations, though our intention, idea is to restrict the timeline, but we are dealing with human affairs. See, we are not sitting in a laboratory doing scientific experiments. We are dealing with real human beings' problem, and we do not know what kind of problem may arise in our life experience. Therefore, law will always remain, flexible. You cannot have a fixed time. You cannot do that because that may defeat the whole purpose. The interest of person may be jeopardized if you have a very strict pedantic view, mechanical view of this is my personal view. So, of course, all attempt must be made to see that we do not go beyond the framework. And only in exception cases that we should. Otherwise, yes, we should adhere to the timeline because that's the whole sense of arbitration. It was enacted, it was meant to reduce the burden on the court and also save cost. Well, cost we'll talk about it also when the time comes. Yes, and a party autonomy, very important things have been also. Why should we, the court, be burdened about appointment of an arbitrator? It should be left to the institution. In fact, that's a very good idea. Actually, why should we do this? Because we are dealing with basically, therefore I think, as mentioned, Jasmeet also raised the issue, how to deal with this. Because why all this kind of arbitral awards, which looks very arbitrary, is because of the fact that the arbitrator themselves are not equipped. See, we are beside certain dispute. There is a list, and it has to be decided in a manner known to law. Obviously, when I say law, but to be given, it should not conflict in contradiction, in contrast human reasoning, rational thought process. So there's so many cases which have been come up that the arbitration award is without any reason at all. Just just few lines of sentences. So we don't know whether really there has been proper application of mind or not. Because after all, it has to be a product of application of mind. These are basic, at least those who are in legal fraternity are trained to do that. We are trained to see whether any decision made is based on rationality, reason, and of course the basic sense of what we consider to be correct. So these are issues which will trouble us. So we are not going to have a very easy solution to arbitration. It is going to be there. This seesaw, this between section, in spite of section 5, there will be cases which will keep coming. And it will certainly keep coming at least to Supreme Court, I know 136. And 142 will be also involved. Complete justice, which may be missile. But then was. But see, because, and India, why I say so, because see, India is such a vast country. Very, very complicated, complex society. What we think in a particular region of the country appears to be very just and fair, doesn't gel in other sections of society. So the sense of justice also differs from region to region. I'm not saying very vastly, but then they have the perception of what is good, what is bad. it certainly influences justice delivery system. Therefore, it is going to be difficult to have a very uniform and which fits all kind of situation. Like any other arbitration will also have this problem in our future. And we are dealing with arbitration, yes, sometimes we think only of the government agencies also. See, government agencies have certain norms they have to follow. The structure there. Somebody has to take a responsibility. A person in charge of the government undertaking, for example, he is bound by certain norms of the government, certain policies of the government, which is not there in private entities. See, private entities may think, yes, I don't mind losing in this game. Okay? This arbitration, I will lose it, no problem. But I know there's another, see, financial transaction which is going to take me off. So he can gamble also. He can afford to lose in one arbitration proceeding and to ensure that in the other arbitration proceeding, so these are not, see, available in a government institute, undertaking agency. Therefore, obviously, there will be variation in approach also. So these are certain areas I thought while discussing this. Well, the role of judiciary will be always there so long as the statute. Whenever so long as the statute is there, the role of the judiciary will always there to interpret. Konkan, for example. Then MediateGuru also. What is arbitrability? The whole issue at that judgment is based on that. And what cannot be arbitrated. Whole judgments have been devoted to that. Then what is this arbitrators' impartiality or others? Then again, that's what issue. Perkins also, that was also where the Supreme Court had dealt with. New emerging also where the validity of emergency arbitration, imagine others. So these are emerging areas. Again, we don't know what kind of situation may be placed before us because of these changing times. And today's world is very, very uncertain. What will be the tariff today, we don't know. 25% is said, but we don't know what, there will be some diplomatic, understanding, negotiation, it may change. But then some people might have already exported or imported, paid their tariff, and how to deal with it with changed tariffs. So again, so this international relationship is so volatile. So obviously you can't have a very fixed norm of what is good, just legal principles. These variations will be there. The flexibility has to be there. There again, the judicial interpretation again will be there. So, howsoever the law says, avoid these courts, judges, somehow they will be brought in. They will drag in. The kind of, reluctant judges will be dragged in. This is, Hemant Gupta had rightly said. So why should we be bothered about appointment of judges, arbitrators? It's basically administrative work which has been said by Konkan. Do it, let it be done by institution. Nevertheless, these issues keep coming up. So we don't know, I can't say, at least from my experience, I don't know how far our reluctance or limitations of the court's interference will be, to what extent. It has to be judged from time to time how it evolves. Yes, much has been spoken about enforceability and finality. Big issue. Is known everywhere. To execute the decree. Yesterday, a case came up. This certificate, sale certificate. 2010 census, we don't know. So that came. We said, these are issues which keep coming. We don't know what is the reason. Of course, we have issued notice. We'll see how. There may be good, genuine reasons also. We don't know. But nevertheless, these are issues which keep cropping up in the court. Well, arbitrator independence and accountability, this is very, very important. It lies, in my opinion, it goes to the root of the success of arbitration movement in India. We are judges, we are trained. Lawyers, we are educated. Knowledge in a very systematic legal paradigm. Parameters are there. What is right, what is wrong, what is illegal, what is irrational. See, all these issues are all been taught. We are trained to do that. Whenever an issue comes up, we always think with these parameters in our mind. But as rightly said so, there are many technical, very fantastic person who knows the working of the system, but they have no clue of the principle of natural justice. It's so, अरे क्या सुनना है इसमें? तो ये तो is patently, is demonstrable that is wrong. But फिर भी तो you have to give an opportunity. You have to basic. See, it doesn't enter there because they work in a bureaucratic mindset. In a bureaucratic mindset, when a bureaucracy, he doesn't have to listen to anybody else. All the papers is brought to him. He says, "Oh, this is correct. This is as per it conforms to the law." So he said approves. It doesn't conform, doesn't approve. Same thing happens when he is a member of our tribunal. ये तो confirm करता है, ठीक है? There is a basic thing called basic principle of natural justice, which is always, when we see in the court also, we know that nothing in this case. Sir, आगे सुने nothing, फिर भी सुन लेते हैं इनको. That's the habit. That's the mindset of a judge or a judicially trained or legally trained. I won't say judge, a legally trained person. आप हमेशा देखेंगे to give an opportunity to the other side. Let us hear him out. These are mindset which has to be inculcated, which has to be experienced. So this is a big, therefore I feel that one of the issues is about this, how to train this arbitrator, technical person. We need also. हम लोग तो generalist है. All the judges, lawyers, most of are generalists. We are not expert in this. And thankfully that, like this 50, 60 of you here, I know, or you are really being, practicing or, studying arbitration as a special subject. So I can say you're a specialist. But many of us are not. Many of the judges, at least. Some judges are special in the area. That's so wonderful. But we don't appoint judges on the basis of their specialization only. Yes, many judges are being appointed on the basis. But if you see the nature of the Indian system, legal system, it comes from the bar and it comes from the service also. As far as the bar inductees are concerned, you can choose. Okay, this lawyer has been, an expert in this field. इनको ले लो, IP में है, taxation में है, very good. But these service judges, services क्या करेंगे आप? You can't. I'm talking of the High Court, not the Supreme Court. Supreme Court is beyond my. I can speak of High Court because I was part of the system of collegium, so we knew how to deal with that. So in service method, there nobody is taught in a specialized. Nobody is required to be specialized in a particular field because today every 3 months there is a transfer in the district judiciary. Or he, she is dealing with family court. After 3 years, he will be sent off to labor court. After 3 years, he will be in civil court. After 3 years, in the narcotics. So, there is a whole blend of knowledge, but not really an expert in a particular field of law. With this coming of the arbitration, you can't afford that. You have to have a specialist in arbitration law. So, how do the High Court judges deal? Jasmeet Singh, after you have been practicing in commercial law and all this, so you have some, you can put on your hand, very comfortably. But there are many service judges who have not really practiced in the legal also, because you can't blame somebody who had never had the opportunity of practicing or dealing with these cases. So these are problems in the high courts. Similarly, when it comes to arbitration, I feel that we must really train. And why should the arbitrators only be judges or retired judges? Like I'm also, dreaming of being, but why should the litigants go only for judges? They must have lawyers also. And I feel that lawyers also, like the mediation. The mediation is coming a big way. The Parliament has made Mediation Act 2023. And they are going to change the entire landscape in mediation, making it much more informal. Taking away from these rigmaroles of this strict, judges and lawyers, dominating everything about law in this country. they're going to take away that. And they're going to use those persons who have this, trained in mediation. So I think we also need this kind of law changes to build more trained arbitrators who can do wonderful. Once we shift from this ad hocism to the institutional form of arbitration, I think there I think we can see much more improvement. At least you don't have to deal with it in section 34. You'll have a better opportunity of dealing with better awards. So now cost factor. This is something I really can't say, because it operates in a very different manner. See, in a normal judicial system, the judges, the client don't pay for us. Do the client pay for the judge's salary? Is paid by the state. The client pay only for their lawyers. In the arbitration, the litigant has to pay for the lawyers as well as the judge. Double whammy. So it is therefore it is a very kind of that is also one of the reasons why mediation has not really taken off. Because the parties feel that I already paid to this lawyer, why should I again pay to this mediator? And mediator, obviously they have to survive also, they have to lead their life, and without being paid, how do they discharge their duties? So this is a problem. The cost factor, as far as lawyers' fees are concerned, I have no comment to say. Obviously, there cannot be any cap. Can you say that the lawyers can't charge more than this? Not possible. You are trying to do something impossible. I think therefore, let us not think of that. Let us leave to that. But what about the arbitrators? There can be a cap. Even judges also, non-judges also, who work as arbitrators. There may be some modalities how to work it about it, but make it attractive. See, it's very important. Otherwise, we'll end up the kind of situation where the Supreme Court of Singapore had to say, otherwise you'll end up cut and paste. So party का नाम change कर दो. So how do we do this? I mean, there has to be much more professionalism in the arbitration movement, which is required, and this can't be to the courts, because courts have nothing to do with this. The laws are made by the parliament, and this kind of interactions, I mean, I feel it's very, very important to make this arbitration movement really robust, because that's how we can exchange our ideas where our movement is faltering, what are the areas which are of concern, which this can be developed only through discussions like this. Yes, there of course, though we may see that, we may feel that there are challenges, there are issues, but I feel arbitration has a huge potential. In fact, I wish it takes over many parts of our judicial system. First of all, it will help in unburdening the judicial system. So many, just like in commercial court, section 12A, the mandatory provision, the pre-litigation mediation is compulsory. I think maybe, I don't know how to bring in arbitration to that. It will require a little bit of legal kind of 24 mediation agreements. Bill. So let us see that, because that there needs to take away from this pure very rigorous legal kind of environment in a more informal manner. Arbitration is one of them, and of course the online mediation. Online mediation is a very big thing. Is coming up. The huge, I think, potential mediation has taken off a lot of roads. Sir, आप जानते हैं ना, all these family disputes, transfer में आते हैं, disputes between wife and husband, you know. So invariably, whatever may be the nature of the dispute, we make an attempt to mediate. So we refer to the Supreme Court mediation, and about 50% comes successful. So we are quite happy, not because we are unburdened, but because when the mediation takes place successful, both the parties are happy at least. And we decided some party will be unhappy of the decision. So arbitration also, there is no reason why other person should be, because he had all opportunities to interact in an informal manner. Because as far as judicial official or the judicial forum is concerned, you do not know till the last minute. Till the judge actually renders the opinion. But in arbitration, you can somehow feel, kind of assess also how the arbitrators are going. You can try to make your points. But it's not possible, obviously, in the structured judicial system. And use of, I see that with the use of technology, we perhaps can enhance, expand it to more informal also areas, online forum. And there's of course that issue which has been also raised about third-party funding that is relating to cost, because sometimes so costly. But that is another area of it has to be examined properly. What will be the relationship? What will be the liability? What will be the accountability? To what extent the third parties can the whole possibility of influencing the arbitral proceeding. These are areas of course concern. We can learn from other jurisdictions also how it is evolving. And of course, as I see that one thing which always concerns whenever I go to address any law school or law college, what is my concern is I can see thousands of students. Every year I think a lakh of students are graduating.
Correct.
Where they are going to be absorbed? How many are going to be judges? How many are going to be litigant lawyers, litigating lawyers? A big challenge, and they are very talented also. Huge talents, I can see that. In our times, except those who have really decided to join law, 90% of the law students were for various other reasons. By default. At least I know in my law faculty, एक तो DTC पास होता था, 12.5 rupees, yellow pass, बहुत अच्छा होता था. You get a hostel also, and you have a library also. Then you can prepare for the UPSC. So these are all incentives to join law. But now today things have changed. The students, they really try. That's why we have this class. It's huge competition. It's a cutthroat competition. You don't get it. Through CLAT and some of the universities and law schools are imparting excellent first-class education, real education. The kind of academic standard is so high. So all these products, why will they be? In fact, they only talk in Supreme Court. They said, stop these law clerks who are attached to, law interns who are attached to these lawyers not to come. In fact, yesterday I saw that the Supreme Court has, or I don't know, the bar has a resolution that they will not enter the law interns Monday, Friday. Because otherwise, this. See, and I feel sorry for them because they would have missed the opportunity to see the Monday and Friday activities. Monday, Friday activities is very different from the non-students, the young lawyers. Where do they? It's a huge opportunity. Arbitration, mediation, and all specialized knowledge. Cybercrime, AI, all lost. Therefore, a young student, talented student, does not necessarily dream instead of being a judge. Fine, very well. That's an opportunity one should always try in the judicial system. Or a lawyer. Well, there's nothing so fascinating, so exciting as being a lawyer. There's nothing more than, sir knows. Sir also. Jasmeet also, the kind of autonomy, the kind of, the kind of freedom. Decide on you are a master of your own. Money.
But she's missing now.
Missing, of course. That's why we are requesting senior advocates to pay something to the junior Baba. Otherwise, how do they start? And gestation period is long. And you are not going to all the seniors standing here, sitting here, who not allow your juniors to appear in the court. Arey Baba, you have just learned first. Arey drafting sikho pehle. Observe these court practices. 5-10 साल के बाद आ जाओ, अब appear करो. How do they survive during that period? So litigation is a very challenging task. Except for those who have already some arrangement made, so is there. So these arbitration, mediation, AI, and there's so many tribunals also coming up now. All kind of service laws, taxation. So these gives a whole opportunities opening up. So this is something certainly arbitration is going to be a big kind of field of practice in days to come, because the parties, especially the companies or the business firms, they don't want to waste their money. They are set up to earn money, not to waste money by giving to lawyers and the arbitrators. So want to save time, money. So arbitration is evolving, is going to be a permanent part of the structure of the legal system, in which the arbitrators, both as lawyers as well as future arbitrators, going to be opportunity for the lawyers. Yes, there are certain, of course, I mean, there are certain disturbing trend recently what I have noted is because of this undue delivery. Even though arbitration was supposed to be a very efficient, fast and less costly, it has been found in our practical life that it is becoming very, very expensive and also very long-drawn affair. So the government of India has issued a notification recently also that there are no arbitration clause in those cases where it is less than 10 crores. Above. More than 10, but less than 10 crores no arbitration. And again you are creating problem for the courts again. See, for the court, whether it is 10 rupees or 110 crore doesn't matter. Because we are going to decide on the principles of law and the facts. We don't decide, we don't give our time, invest our time on the basis of the amount involved. So for the court, it's same thing. Whether it is a less than 10 crore or more than 10 crore. So again, is a problem for the judiciary. But this the government has taken on. In fact, Karnataka government has issued an order. Let us all these new contracts, no arbitration. Itne kharcha hota hai. So this is something which has to be taken note. GCC. No GCC. So this is something which is a little bit of worrying. It does not help the arbitration movement when we are trying to say that yes, ease of doing business. If we have this kind of clauses, this is not going to help us, because if we have to help arbitration as a movement, a robust legal movement, and then the government must play a much more proactive role. Established, as Sir has said also, the chairman of the arbitration council has not been previously. So certainly, had it been established, perhaps you could have seen few steps more towards more improvement of the movement. So as I see, yes, there are issues. I'm sure it will be resolved, and of course, a lot of huge potential. And I'm so happy that these kind of discussions will certainly make this arbitration movement strengthen. And I'm thankful to the author and the organizer for giving me this opportunity to share a few words. Thank you, and all the best. Thank you so much.
Thank you, Your Lordship, for your inspiring word and valuable perspectives. As we draw closer to the culmination of our discussion segment, I'd like to invite Ms. Shruti Khanijow, partner at Shardul Amarchand Mangaldas, to the podium to deliver the concluding remarks. Ms. Khanijow, your ability to synthesize key takeaways will be invaluable.
Good evening, everyone. Thank you for your time, and I know I stand between you and the launch of the very book that we are here to attend. Honorable Justice Singh, Honorable Justice Rastogi, Honorable Justice Hemant Gupta, and Honorable Justice Jasmeet Singh, and of course Param, and all the friends gathered here, ladies and gentlemen. I'm not going to take a lot of time. I know we have a lot of good thoughts to ruminate as we stand and we get the book inaugurated. Let's just think about the fact that Arbitration Act in India is still a teenager. It's 19 years of age. Next year it will become an absolute adult and enter its 20s. So we had a lot of candid views, a lot of incisive thoughts, a lot of genuine concerns of how the country is really moving forward. As for me, I've practiced international arbitration for about 10 years and then folded more into litigation related to arbitration. So my perspective will be a bit different, and I would candidly admit to the fact that the reason backlog for arbitration exists is because of us lawyers. We use arbitration as a real strategic tool to ensure our clients get what they really want. At times they do get it, at times they don't. But as they said, we do earn our money, and we do believe in third-party funding these days to ensure that the client interests are not taken care of through that. I'd say that arbitration, not just being a strategic tool, has come into play. Mediation also has acted to it, and Param is somebody who has promoted mediation as much as he does this cause for arbitration as well. So arbitration, mediation coming together has really revolutionized the way alternate dispute resolution in India is working now. The book itself talks about clause to closure. The clause itself now, and what we recommend, at least as law firms to our clients, is to look at that clause very carefully, see where it's going to land up in enforcement. Another point that was discussed today and put forward to say how enforcement is really key to why ADR really exists. It's the same as litigation. As long as you're not able to enforce your decree or an arbitral award, it's as good as paper. A few of my former colleagues here who I've worked together with on international arbitrations would testify to the fact that half of our time goes in enforcing a judgment or an award as compared to really taking that matter forward with arbitration. As regards when we spoke about institutional arbitration, so two good things happened to me in the last 2 years. I started getting appointed by institutions, international institutions, as arbitrators. Now, initially I was really excited about it. Oh yes, my career said I'm finally an arbitrator by an institution. But you know, when I was attending these proceedings as an arbitrator sitting there, it made me wonder and think about the due process that we talk about, the principles of natural justice. All of the institutions which we currently talk in very high reverence about, they're not Indian institutions. They're not very clear about how Indian justice system really works. So when I talk about due process, their timelines, the way they think about costs, is very different from what we think about. Now, as an arbitrator, when I sit and I get an application about I will not be able to follow this deadline because of certain reasons. Those reasons are very interesting. One of the reasons would be an ED raid has happened at my client's office and the documents are not available. As a lawyer in the present generation, all of us know the documents are online, everything's available. This is a delay tactic. But can I question that as an arbitrator? The answer would probably be yes, but can I not give them time? The answer is no, because the due process requirement will come up. And that itself may be a ground to challenge that award that I finally give. So these are the kind of concerns that I, as a young arbitrator in institution appointments which don't happen to be Indian, have faced. And I think these are things that need to be corrected or perhaps looked at a very close when we talk about institutions. And I think IIAC would do a great job in bringing Indian reality to the rules that we really come forward with. With respect to what we heard today, I think Section 34, I'm one of the parties who's guilty in filing quite a bit of them. But we do ensure that now, at least in terms of how we draft the applications, petitions, given that AI has come into play, we do ensure that AI does assist us as lawyers to avoid repetitions, to put points a lot more clearly and precisely, which we did not do. As somebody who's practiced and done international arbitration, I can see very clearly why this is a concern in India. We do tend to have very lengthy pleadings as compared to what we see in the UK or probably in Singapore. But the reason for that is also because we are used to having lengthy pleadings. At times, if you don't put in a lot in your pleadings, there may be a risk of losing the ground or losing a point or just not putting a point across. So as a matter of arbitration culture, perhaps it's on us as lawyers to actually make our pleadings, notes of summary submissions a lot more clear and concise, and perhaps a lot more of advocacy to be done by pleadings instead of in court, which saves a lot of time from the international perspective brought in here. I also recently moved to south of India. I realized a couple of high courts have this very interesting manner of disposing of Section 34s. They don't permit replies in Section 34s. They have notes of submission, summary notes to be filed. And if those summary notes are not filed, Section 34 is disposed of just on Section 34. Because there's nothing new that you would argue with Section 34. So and this is specifically in Madras High Court. It's just been 2 years that I've been practicing there. And I found this really beneficial for disposal of cases.
That's why this is a different perception, how the practice in different regions is so important. We can learn a lot.
This would be my 2 cents before I pass on the mic to Param for the launch of the wonderful book. Thank you so much.
Thank you once again, Ms. Khanijow, for providing such a concise and impactful summary of today's discussions. Ladies and gentlemen, now we arrive at another pivotal moment of our evening. The official launch of a book that promises to be an indispensable resource for anyone involved in arbitration. Arbitration from clause to closure. To lead us through this exciting presentation and the formal launch, it is my distinct pleasure to invite Mr. Param Bhamra, founding partner, MediateGuru, to the stage to provide a copy of the book to our esteemed dignitaries. Mr. Bhamra, the legal community eagerly awaits this contribution.
Sir, can we stand up and for the reading?
Starting with 2 volumes. 250 pages each.
So please have a seat.
Thank you, Mr. Bhamra, for the official launch of what will undoubtedly be a seminal work. And now, to offer the formal vote of thanks for this memorable evening, it is our pleasure to invite Ms. Tanima Tiwari, editor of the book, Arbitration from Clause to Closure.
Good evening, everyone. It's my great honor to be here to present the vote of thanks. And I'm getting nervous because such an esteemed guest here. So, as we reach the end of this wonderful occasion, I'm reminded of a powerful thought, which is Karmanyavadhikaraste ma phaleshu kadachana. You have a right to work, but not to the fruits of your action. This powerful wisdom, the idea of putting in the effort without caring about the outcome, has truly guided us throughout the journey that led to this evening's celebration. Our deepest thanks to our distinguished panel, Honorable Mr. Justice M. Kotiswar Singh, sir, Judge, Supreme Court of India. Honorable Mr. Justice Hemant Gupta, former Judge, Supreme Court of India, Chairperson at India International Arbitration Center. Honorable Mr. Justice Ajay Rastogi, former Supreme Court Judge. And Honorable Mr. Justice Jasmeet Singh, Honorable Delhi High Court Judge. And Learned Shruti Khanijow ma'am, partner at Shadul Amarchand Mangaldas. Thank you from the bottom of our hearts for giving your precious time and energy here. This book, Arbitration from Clause to Closure, is a result of months of tireless dedication, countless hours of detailed research, and a commitment to create a resource worth reading. It stands as a testament to perseverance, hard work, research, and a kind of wholehearted dedication to make this thing happen. And seeing it finally here in my hands is a distinguished honor to present this book, and I feel immense proud and my heart is overflowing with emotions to present this, that the work in which I have contributed in is finally here in my hands. Words feel insufficient to express the profound appreciation to Advocate Param Bhamra sir, who first thought of making this book a reality, and he gave me a very fair chance to prove myself, to prove my capabilities, and to prove that I can do something and I can contribute to this. And I wholeheartedly want to thank him for all the motivation, all the enthusiasm from his side. And he somewhere knew that I can do this when I even wasn't aware of the same. So, and I also feel that God has always been very kind to help me throughout this journey, and he has never left my hand behind, and he has always supported me throughout this whole journey of editing this book. And so equally thanks belongs to him also. To each one of you who are present here right now before me, I express my heartfelt thanks to everyone to join us in this beautiful evening of launching this Arbitration from Clause to Closure book. And thank you sincerely for providing your very valuable time to this book, to the launching of this book. And thank you so much to all the esteemed judges, esteemed honorable judges here who are present here for this book, Arbitration from Clause to Closure. And it's my immense honor. I don't know, I'm getting emotional right now, but yeah, it's my name on the book. So it's a distinct pleasure for me as well. And to all the volunteers who are present here, to Anisha, to Durga, to Harsh, I'm very, 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 very thankful to each one of you, and to every sir and ma'am, and to every other person who is present here right now, including Param sir, whom I have a distinct pleasure of calling my mentor as well. So I don't know what to say right now. I'm feeling short of words. But yeah, I feel very, very, very proud to be here standing right now in front of you all. And thank you all for giving your precious time, energy, positive energies, and everything to me and to this occasion this evening. And it was very hard for me to I just want to share a bit of something. When I was editing this book, I felt at some point of time that I can't do this. I think this is not my work, and I think I will not be able to present that quality and that kind of commitment to sir. But God, Shri Krishna has helped me a lot in this, and I hope that He will be with me, and I hope all your blessings are with me right now. And sir, as I am a law student right now, and I think that, and I believe that I want to be a litigating lawyer someday, and I want to be to become a successful senior advocate of Supreme Court, and successfully I just want to be a judge of the Supreme Court as well someday. And you all are my inspiration, and all are. I mean, I cannot tell right now, I'm feeling short of words, but I'm feeling so good right now. I cannot tell I cannot express in words even. And as we conclude this evening, I can say that I'm not only taking back positive energy from here, but also the invaluable guidance which everyone here has provided me. And Honorable Mr. Justice N. Kotiswar Singh has very rightly said, and I have noted it down in my notebook also. Justice can be different for someone else. Justice can be different for someone else. So when I was in a moot court, asked, so I was in the final rounds of moot court, wherein I was asked that what if there is a justice to someone and there is injustice to someone? So I replied that there can never be a justice to every other party. I mean, one party has to compromise and one party will win. So for that, justice is for him. So he very rightly pointed out that justice is what is fair, is what is very is what is to keep in mind about the natural justice, which you all have very supremely talked about. And then I said a line that which I have already studied in the Supreme Court judgments, that it is a judge on the trial and not the parties who are on the trial. So it's an immense honor for me to be present here. And from here, I'm not only taking the positive energies of everyone present right now, but also I will forever cherish this moment. I think what do I say? Till the last moment of my breath, I think. And this is a very profound kind of opportunity for me. And thank you so much, judges. Thank you so much, Justice Gupta, sir, for writing up forward for the book. And thank you so much, Ajay Rastogi, sir. Thank you so much, Honorable Mr. Justice N. Kotiswar Singh, sir. Thank you so much, Honorable Justice Jasmeet, sir. And thank you so much, Shruti ma'am, for being present here right now. Thank you so much to all the audience.
Thank you, Ms. Tiwari, for those heartfelt words of appreciation and emotion. As we conclude the formal proceedings, we would like to once again express our sincere gratitude to our esteemed dignitaries, our insightful speakers, and the brilliant minds behind Arbitration from Clause to Closure, and each one of you for your invaluable presence and participation. Your engagement truly made this evening special. We hope you found this evening's discussion both informative and inspiring. Thank you all for joining us, and a very good evening. We request all the organizers to join the honorable dignitaries on the stage for a photograph.
So I think we can you all good people to come. This is called mission, not mission. You are just focusing also.
Thank you.